Hey y'all, it's me, it's your girl, the real deal, Lenita Skills Reaction Channel. Like, share, subscribe. Welcome, real deal. Please don't forget to smash the like button and subscribe if you haven't. Thanks. Keeping it real, your reaction means a lot to Lenita. Thanks. Today we'll be looking at YNW Melly W murder trial court hearing. Is going to continue in a minute. Okay. Good morning, friend. I know you'll be back on. You know this your thing right here. Yeah. You know this the hearing, right? Okay. Now you know what today is, right? You know they trying to get rid of your girl. They're trying to get rid of Bradley. But see, when they get rid of Bradley, they don't know Brayley. They trying to get rid of Brayley, Christina. But when they get rid of Christina, it's gonna get worse. See, they need a man on it. So I think they did that on purpose to get rid of Christina to bring that dude in there. But the dude they got in there, he harder than Christina. But they don't know that though. Everybody think that if they get rid of Christine, it's gonna be good. This gonna be their worst nightmare. But Melly, shoot, Melly gonna be in there for a while. Melly gonna be in there. Melly ain't going nowhere. Now, allegedly, his girlfriend's supposed to testify. The Instagram message from the girl mother. No, but I seen it. I had did a no, I ain't seen that. No. But I seen the girl. I got child in the girl and the girl mother. But I ain't been on Instagram in a while. But see, what it name? Portland messed that up. Portland, Melly, and the blood. She said the girlfriend said she wanted to testify. Oh, now see, I seen the one on YouTube. You talking about the one? You talking about with the one with the when they were questioning the girlfriend, and then the mama got on there. I think I seen that one. I recorded that one. But the girl said that she want to testify. The girlfriend said she want to. But Melly don't want her to because he thinks she easy. She's easy going. What? When was this? When was this? Because I seen the YouTube one. What that mama doing? The mama need to not the girl. Now, now when was this? Because I got the first one when she got the interview. And she was talking about Melly. That sound like the same one. It sound like the same one. It sounds like the same one I'm talking about. But I don't remember her talking about boiling though. I know they was talking about Christine. And they what? The mom did. You talking about Instagram on YouTube? On YouTube, it was when they interviewed it. When they interviewed it. When they interviewed her, and she was called him Goofy. She wrote more than a message. I ain't seen that one. What she what she doing writing to Boylan? Let me see, can I find it? You say I can find it on Instagram? YouTube. It's not on YouTube. Is it on Instagram or YouTube? On Instagram? Let me see, can I find it? Hold on for a minute. Let me see. I'm about to find it. What? Let me see. I don't see it. Wait a minute. See. Let me see. I bet you talking about the same one I'm talking about. Hold on for a minute. But I ain't see her on the one on YouTube. I didn't see her release anything. Hold on, let me see. Let me see what I gotta put it up. Let me see. Can you put it up now? Can you put it up now on Instagram? Put it up on Instagram.
Climate change is here. But we need political courage to act on climate change.
Come on. Taking them so long. Let's see. I'm gonna put Melly, girlfriend, mother, wrote, I ain't see this. I wish you if you know what it's under, because I can't. I believe we talking about the same one. It's not but one with the girlfriend on it. It's not but one with the girlfriend on it. When she was talking to Law and Crime. Yeah, the girlfriend was talking, and then I didn't know the mama was in the room. I bet we talking about the same one. I bet we talking about the same one. You ain't talking about the one she said he ate Goofy. Oh. Mm. Well, no way. I ain't been on Instagram in a long time. I was looking on that. I can't even find it on Instagram. What she write him a letter for? What she write him a letter for? Cause he the one tampering himself with her. Excuse me. Oh, let me see. We still come on, wonder what they doing. I'm gonna take a. I wanna see it, cause let me pull something. Hold on for me. Let me pull something up. I believe they brought that up. Let me see. Can I find? I think she guiding. I believe her mother guiding her the wrong direction. I believe. See them mamas in them children business. I don't think they driving them in the right direction. Let me see, Melly. Girlfriend. Cause she was trying to protect her daughter and they found her. See, her daughter probably running her. See, her daughter, see the girlfriend allegedly is involved. She know about the whole thing, but she don't want to tell nobody. See, I believe she when it's time for them, she gonna take the stand. But they think that what it is, see, they think because they get rid of Christine, it's gonna be worse on them. Cause that man that they got, that other man prosecuted, that man, that is whoa. He don't play. That other prosecutor, they try to run over him. Yes, what was it? The other day, and honey, he went back on them. They ain't gonna be able to deal with that man right there. He good too. So they went from good to good. They went from good to better. Let me see, brother. Better. Better. Two boy. Let me see, can I find it this way? I wonder what taking them so long. They messing up my little nap. It's after 10. Um, what's the matter? I don't see it. I believe we talking about the same one though. I bet we talking about the same one. Wonder what they doing. So there go the people coming in the courtroom. Man, this thing right here about to be good. I think they need somebody stronger than Christine in this case right here. They need somebody strong because this thing right here, it about to be some fire. It about to be some fire, y'all, baby. And she gonna have to be strong. You got to be strong because you can really deal with these folks. Why taking them so long? They told her it was gonna start at 10. No, they said at 9. Had to go to work. I ain't even took no nap. Okay, I see where you got that track one. Hold on, you just sent it to me. Hold on for a minute. Let me see. It's different. I'm trying to find it for you. Well, what was that you just sent me? Let me see. Okay, I got it. Let me see. I got it. Oh, I ain't know nothing about this child. What she got? Oh, the mama told him to leave her alone. You have ruined enough lives. Let her live hers. She don't need his money. She always live good. Sure did. What's up, dog? I got it now. The letter that her mama sent, the letter that her mama sent to Boylan. Melly not the only end with money, and at least I know she won't be harmful. He's evil and he's snaked. Someone who didn't snake, someone who didn't snake him karma. My baby blessed because she done nothing wrong. What is it? Wait a minute. Oh, she say he's evil and he snaked someone who didn't snake him, Carmen. My baby blessed because she done nothing wrong to anyone, to any of you. But you keep bothering her. She could have ended Melly months ago. Melly's slow. He's talented, but he has no brains. You don't cross everybody. I think your life's going to be great. going to be great. I think your life going to be great. We only loyal to you for one reason. You beneficial as soon as you stop. He'll snake you too. We will get the last laugh. So y'all enjoy y'all money and we'll enjoy ours. Oh. What? My daughter didn't tell on Melly, or he would have never get out. He hypothetically told her everything. Oh, Melly told her everything. What? I knew she knew everything. I knew she knew. My daughter didn't tell on Melly, or he would have never got out. He hypothetically told her everything. She knows what you know. Uh-oh. He told her the morning of a blank house. She didn't tell them people what he told her. Uh, there would never be any getting out for him. But since all y'all gunning for her and she's scared for her life, let y'all boy know everything he told her in the house. I after the year of this
I gotta get back long.
and that is slow. He had his back. That was what they already know. But the he told her and tell y'all her dad would be home in 30 days.
Yes.
So I'm gone.
You deserve it.
I'm grown up. What the hell was mad? He gonna send 5. Melly wanna play dirty? Well, tell the Lord we know S. They don't even know. And we have decided to cooperate. What? He dogged my child when she kept his secret. He all gloves, humble, sweat, loyal. Y'all A would never try me like that. That end would have to pay me for that secret. But she not money hungry. She was loyal to a man she thought loved her and loved what it got. So got her. So y'all send them goons to what? Whoa. Man, thank you for sending that. Wow. I haven't seen this. Melvin sure is. Demon, he said on YouTube. He said he got 2 people on him. Millie and Melvin sure did. He said that himself. Wow. Yeah, I didn't know that. On track. I didn't know that. I did not know this here, honey. She might talk then. She might tell. Girlfriend might tell on them because she said she know a lot. Golly. I ain't know nothing about that. I ain't know nothing about that now. Wow. This case right here. Oh, wait. Whoa, boy. Oh, wait, this is crazy. I ain't know nothing about all this right here now. I ain't seen this. This is new for me. Dang. Whoa, wait. Yeah, Melly too. See, and that's what they doing now, trying to mess everybody up. See, that's why he don't want Christine on it, cause Christine know a lot. Wow, I can't believe this. Golly. They probably had promised the girl in the mom some money, but they didn't pay them after the trial. Yeah, they supposed to have bought her Mercedes. But about the daughter of Mercedes told that lie. They ain't got no money like that. They want to be. If he had some money, he wouldn't be trying to kill them two boys. He wanted that money they had. Yeah, he want their money. Wow. Because if the mom is talking like this now, well, why did act the way she act during the trial? That's what I'm saying. See, that's why they were talking about that's why she was talking about what her name? Christine. See, Christine knows she knew. Yeah, she was lying for him. Talking about she was scared of Christine. She ain't scared of Christine. She's scared of Melly. See, see, when she got in front of Melly, Christine asked her those questions. And I get that lady say, I'm not about to stay there in front of all these people. Wow, this is crazy. I'm glad you told me about that. This is crazy. See, she want to put it, the mama want to put it on Christine, but really it's Melly mama. Melly and his mama, she working about it. But she want to play gangster. I wonder how her daughter got mixed up with Melly in the first place. She knew who Melly was. He went to the same school she went to. I know why they ain't stopped again. They gotta come on now. I gotta go to work. Wow. Oh, wait. This thing is, boy, you don't send that to me. That thing right there is crazy. Move, Minnie. Come on now, sit down. Oh, you little dogs. Um, mm, mm, mm. Mm-mm. See, I wanted it. This is what I wanted to do. I wanted to take Chris or nothing she done. I wanted her to come off because I wanted them to get somebody harder. They're gonna need in this case right here. I don't know if she ain't gonna be able to go to Borland. She she kind of soft a little bit to me. She's soft, strong, but she ain't that strong to me. But that other prosecutor, that dude, oh shoot, he a little harder. So I think it need to be men's because when they put that new man, took the black guy out on Melly case and put the other white dude in there, he not gonna be able to handle that man prosecutor that we got now for the state. This gonna be good. There you go, showing them teeth. What they whispering about? Now they're smiling, they telling him something. What they saying? What? They giving him 5. They giving him 5, like something going good. I think they be swelling his head up.
So you're in for my money.
Yeah, I heard you're building a house in North Carolina. Wait it out. I'll show you my house. I got it. Is that where Phil's building it?
Mm-mm.
Well, we're doing 200 miles.
Yeah, they running late today.
Good afternoon. You. Scheduled and for the motion to dismiss. I have this Trost available to comment. She's required to testify. Shows Bradley's in the building, but I'd like to just adopt their testimony from the hearing that we had on Monday or Tuesday. It would be identical. Basically, probably what I would have hoped to have gotten from talking to the 3 people that watched that I can't call. And they found it.
What he talking about?
I think the misunderstanding was that was, they wanted blind testimony from the motions. They need to leave their questions. Wasn't.
Correct, so,
Yeah.
we'll discuss it. We'll discuss it. We should just, who's going to be the prosecutor?
It's not only for today. That was a very major. No final.
Oh, look at them, y'all. They don't got rid of Christina.
Oh, I have, for USC, that it's on the record, but I'll.
Today should be rather quick.
No, I don't want, I,
Yeah.
no, I want to talk about this next, so I was gonna skip over, and I want to keep the arguments and then we forget
And
to
then
be
I guess.
asking. So you guys see this?
And there's been no decision as to who's taking over.
No final decision. It'll very, very, very soon. Yeah, so it's-
I've been asking.
That's fine.
For about 3 weeks now.
That's my attitude, it's definitely, I can, that's my.
So I give you more information.
Accommodate, whatever way. What do you want to say?
You don't need to be talking to them.
United Front. I don't know, understanding that.
So my face is not pretty either, it's just like, as it's trying to proposing, you're just like. No, I wish it wrong.
Third go around, after this comes along.
You could just repeat the rest of the whatever issues is scheduled. Not asking you.
And then prosecutor right there, child, but it's the fake. Then right there, that man right there, good.
I must be ready to start, so I just want to bring them swearing, and just bring them back.
We're.
No, turn that back up, cause I'm being nosy. Mm-mm. You need to turn that back on. Look at him. Look. No, y'all get out of his face. He already know about all of them. Here we go. Here come the judge. Here come the judge.
Thank you. Let's get back on the record, please, and state forward. Dennis, He's present along with his counsel and the assistant state attorney. Do you want to state your appearances?
Daniel Aronson with behalf of Mr. Devons, Stu Adelstein also present, Raymond Liberty, and James Benjamin is back. And Mr. Devons is present.
Good morning.
Good morning, Your Honor.
Good morning, Your Honor. Stephen Klinger and Nicole Bloom on behalf of the State Bar.
All right, so we all set with proceed. We have a motion to dismiss, I think.
Yeah, that's the last motion I believe we have pending as far as the sets that we had for this week. Your Honor, I think we have an agreement with the state, instead of calling Ms. Boutros again and calling Ms. Bradley again, with the court's agreement, we agreed that we would stipulate their testimony that was taken during the motion to recuse and use that as if it was testimony for this hearing to a motion to dismiss, because it would be identical testimony. There wouldn't be anything different.
I have no issue with that.
So it's agreed, that's fine. So regarding the deposition of both of the trial testimony, deposition
Right, the hearing testimony.
of Ms. Boutros and Ms. Bradley. And do you have copies of those? Did you order transcripts?
I do not.
I mean, I heard the testimony. I have notes, but I didn't know if you were ordering a transcript.
I'm sure at some time, well, we have not. I did not know until this morning we had this stipulation or
Well, if there is a stipulation that it's done, is it going to be ordered?
we'll order.
Okay, so then you
And we'll submit it.
get a copy to me.
Yes.
Thank you.
Your Honor, with that said, with that stipulation, we would also now would have been calling State Attorney Pryor, Assistant State Attorney Falk, and Assistant State Attorney Hillary. You have entered your order. We respect your order. We cannot call them. So therefore, we don't have any more witnesses. But I would like to proffer what I believe we would get if, in fact, we were able to call them as witnesses.
Go ahead.
Your Honor, what we believe we would find that if we call them as witnesses is that Ms. Boutros, as she testified to, immediately upon hearing what Detective Moretti solicited to Deputy Gorel, she informed her supervisor, Mr. Killeran. We believe with the testimony would be that Mr. Killeran then went and he talked to the supervisors in the office. My understanding is we will find out that in fact there was a meeting with Ms. Bradley with the supervisors in the office, and when I say that, I believe at times it was just the state attorney, and at times it was the state attorney with Ms. Falk also. I don't know which times they were together or separate, but I do know that they were talked to in conjunction with each other and separate. We believe that we would have testimony that they were instructing Ms. Bradley to file the Brady notice. And this goes back as early as basically in October, November, whenever that was, of 2022. The testimony will show that after they did that, pretty much everybody put their head in the sand. They did not check into things. She went through a whole trial. We sat through the trial. Nothing was mentioned about Brady. We find it hard to believe that nobody would have asked her, even after the hung jury, well, how did you handle that Brady issue? What happened with the impeachment of Moretti? Those are things that after a trial are just talked about. But regardless of, we don't know what was talked about, that's what we would try to find out about. We know that even after the hung jury, Brady, as far as what we're talking about, this impeachment material was not provided. And it continued not to be provided until Ms. Boutros took it upon herself to allow the world to know that the state was hiding evidence. Anyhow, you have the three different Brady notices. You have three different ones as far as the impeachment material goes. And if you notice, one is signed by Ms. Bradley and one by Mr. Killeran. Why we believe the testimony would be that Ms. Bradley refused to sign the Brady notice that was prepared by the supervisors in the office, and she refused to sign it. In fact, it was handed to her by her secretary, and she said, "I'm not signing this." And that's why Mr. Killeran from Public Corruptions had to sign that Brady notice. So she refused the state attorney's basically edict. Then she turned around and she files another subsequent Brady notice. What happens to Ms. Bradley during this entire time? Absolutely nothing from what we know. What we do know is even when we filed a motion to recuse her because of this, the state vehemently has been opposing that. So they didn't sanction her. They buried their heads in the sand as far as what she was doing. They allowed her to do what she was doing after it comes to their attention after the mistrial that she's committed a Brady violation, and they tell her to basically get the Brady notice out. She refuses. When they send out one, she changes it and says that's inaccurate, and they do nothing to her except fight to keep her on this case. That's institutional. Then we're here in front of this court, and I said to Ms. Bradley, can we stipulate to the testimony of Ms. Boutros when it comes to the motions to suppress? Or do I have to bring her back the 13, 17 times? And she says, you got to bring her back for each one. That's retaliation. That's retaliation because she had the courage to tell the truth. And that goes to the office of the state attorneys. You put it all together. There was a mistrial. They hid Brady material. Making Mr. Demons go through another trial is a violation of double jeopardy. Jeopardy should have attached because of what occurred. Now, I filed the motion, and I don't want to go through everything in that motion again. I'd like the court to accept that motion as what I would also do and add it to my argument instead of just being redundant. I believe it automatically is, but I would just like to state that. Anyhow, the bottom line of it is I've cited to the court Glosson versus State and some other cases. I did not cite to the court one case of this fact situation. Again, I don't know if a case of this fact situation even exists, but Glosson tells us that the actions of the state attorney's office can be such a violation of due process that due process demands a dismissal and not a retrial. And that is what we're saying here to this court, that it's the due process violation, making Mr. Demons go through court, a whole trial where he's facing the death penalty while the state is holding on to that Brady material. And then even afterwards, it doesn't get revealed until somebody else has the courage to come forward, is institutional. And if the case I've cited of COURTTV, again, not on point. That case deals with the fact that a state attorney apparently had been sanctioned by his office or disciplined by his office before for comments that he made. And then that trial just goes overboard. The case is reversed. It goes back all the way up to the Supreme Court the second time. And what they basically said is that the case can be dismissed. COURTTV did not put on enough evidence at the trial level when it was remanded. He relied on the original appellate decision thinking that he was a winner. So the bottom line of it is that if you have institutional, I'm not going to say corruption, malfeasance, and it's part of that institution, then this court has the power to dismiss. And under these facts, we ask the court to exercise that power because double jeopardy will be violated if you don't. Okay, sorry. Now, Your Honor, I have here statute 838.022. It is a crime in the state of Florida. It is unlawful for a public servant or public contractor to knowingly and intentionally obtain a benefit for any person or to cause unlawful harm to another by A, falsifying or causing another person to falsify any official record or official document. I contend that Detective Moretti was violating this statute.
But we're going to check only the outside four corners of this motion. Now, I think the argument is not appearing in this motion.
Thank you. Understand your objection. Don't proceed.
C of the same statute, obstructing, delaying, or preventing the communication of information relating to the commission of a felony that directly involves or affects the government entity served by the public servant or public contractor. The state attorney's office itself violated C, obstructing, delaying, or preventing the communication of information relating to the commission of a felony. And that's the felony we're talking about, is what Rder did. That directly involves or affects the government entity, and if they're the government entity, by the public servant or public contractor.
Unwrap good vibes with Brazilian-inspired beauty from Sol de Janeiro.
Or to dismiss it. But more than anything, when you look at all this case law on it, it's really the totality of the circumstances. It's not, hey, if you do A, that's bad, if you do B, whatever. It's you look at the whole picture. And this whole picture demands that this court exercise its jurisdiction, determine that it was institutional, and dismiss the charges. Thank you.
Thank you. Yes.
Good morning, Judge. First of all, I would like to state that counsel was giving a proffer to the court, and then that proffer sort of merged into the case law and counsel's reasoning. So, but that was just a proffer. They don't have that evidence in this hearing, and therefore this court has everything he was arguing about, the institutional problems in the state attorney's office, and there was no charge filed, that hiding evidence, all of that is not on the record for the argument for this motion to dismiss. None of that. They only have what was said in the two testimonies from Bradley and from Ms. Boudreaux. That testimony indicated that the office of the state attorney told them to tell the truth, told them let Boudreaux testify, and let them talk to the defense, and there was no indication of any hiding of evidence. There was no indication of institutional obstruction of justice within the state attorney's office. There was no evidence at all that the prosecutors were told by administration to do something illegal or were told to hide anything. That was all a proffer he gave you, and then he uses the proffer to say, okay, well, under the law, dismiss the case. There's nothing here that would allow the court to dismiss the case or dismiss the indictment. The normal remedy for a Brady violation is a trial. Of course, here that's not an issue because the defendant is getting a trial, and they are aware of the statements that were made by Detective Moretti, and therefore there's no prejudice going into the trial. I want the court to know I'm being very respectful of your orders yesterday. I just have to make a record for the state since we're sort of going back to talking about Brady evidence and materiality in this motion. So again, I'm not trying to underlie what the court wrote. I'm just making a record on the part of the state, which kind of is mentioned in the court's order yesterday on granting the recusal and Bradley. And as the court stated, the state has been arguing that this is a collateral issue. At least the investigations that Ms. Boudreaux and Detective Moretti were conducting when they seized the cell phone from Ms. King, and he allegedly made this statement asking the Deputy Gorell to say that he was there at the time of the seizure. We still maintain that it's a collateral issue. To a degree, I think maybe the court is at a slight disadvantage because the court has only heard maybe people talking about that investigation and doesn't really know the substance of it. And the state would be more than glad to offer.
I'm going to object. I think we're getting into a rehearing on your ruling, not on.
Excuse me. This is counsel's opportunity to respond to the argument. Let them respond to it. But again, both the state and defense could call any witnesses they want at the hearing. Detective Moretti wasn't a witness, was called by anybody. So I really don't know what Detective Moretti would say if called to the stand and testify. All right. So you proceed with your argument.
The state would suggest that if the court would like, the court could do a in-camera inspection of the investigation itself. And that would allow the court to look over the investigation, be aware of all the factors when looking at the issue of whether or not that's a collateral a collateral investigation or not. So the state is offering to the court to provide that investigation to the court for an in-camera inspection to help the court.
What investigation are you talking about, the Miramar?
The investigation into the tampering that ASA Mr. Boudreaux and Detective Moretti were in the room that day and taking the statement from Ms. King.
Who was doing this investigation?
The investigation was being handled by the state attorney's office and by Mr. Boudreaux was handling the investigation along with Detective.
Not the Miramar investigation. I was told, and I thought it came up in the hearing that there was some type of internal affairs investigation that was done by the city of Miramar.
It was later on, yes, sir, a year later.
I just wanted to clarify what investigation you were talking
Oh, I'm
about.
sorry. No, this was just the investigation that Mr. Boudreaux and was conducting at that time into witness tampering. And that would just be with Detective Moretti. They were there to take a statement. Ms. King, her attorney, was there, Mr. Bracken, and that's when the statement was supposedly made. That investigation.
Thank you. Go ahead.
So, again, and now, Judge, I am going to reiterate the state's arguments.
I have to object. He's even stating, he's reiterating the arguments they had on other motions.
Thank you. Bishop. And I'm not trying to rush you.
I
didn't mean that to.
I'm saying it overlaps, so it's hard because in this motion, as the defense says at the very end, and that's the third prong of Brady. And the third prong of Brady is materiality. And to start, I can't answer the motion without talking about materiality, whether the statement was material. It has to be material to the case, right? So collateral issues don't fall under that. It's material to the case. We're looking to determine whether a Brady violation occurred. So when you start with that, the statement must be, evidence. The statement must be relevant, right? It must apply to a matter of issue and not immaterial. And the state's argument has been that this is an impermissible state impeachment evidence based on a collateral issue. That is why we're going to the camera inspection. That particular investigation is not part of the homicide in any way, shape, or form of the facts of the homicide. So, again, not collateral, but the first argument, the second argument being that when you get
Thank you for the super chat.
statement, you're bringing in witnesses, right, that are testifying to something that they weren't party to. Ms. Brennan wasn't there. So for a testimony, she would be coming in and testifying for collateral issue wherein she was not even a witness to the initial incident. So it's not great in the sense that that material is not reasonably probable to cause a different outcome in the trial. That is the main point. That is what they look at. They say, well, you have to look at the evidence. That evidence is going to make a difference in the outcome. And in this case, when you go to the first argument is collateral evidence, and then you say you're going to have the witnesses come in and they're going to be giving impeachment. Well, if the detective maintains the statement and they want to call Ms. Boudreaux to counter that, that is not permissible in the sense that now they're commenting or trying to impeach the witness, the detective, with evidence that of a prior bad act. And you cannot do that. You can only impeach with character. You're going to say character evidence, he's not truthful, you're going to bring in witnesses to show that he's not truthful, that's permissible. But it's not permissible to impeach the detective with a prior bad act. Now, I'm aware that the court, in its motion, in its order on accusing Ms. Bradley, argues that it was material, that the execution of search warrant material falls within the exception to the collateral impeachment. So the court basically was saying there's an exception, and where there's any doubt that the witness might have bias or motive. But again, I understand that's the exception that the court cites, but in this instance, there's no possible bias in the sense that nothing's pending against the detective, there's no charges pending against him, there's no reason for him to come in to lie. So it becomes a little difficult when you're saying, okay, there's an exception to the collateral impeachment rule, but even those exceptions, bias or motive to exaggerate, and I'm quoting from your order, or even fabricate his or her testimony, the defendant has a right to explore that bias or motive before the jury, but there's no indication that there was any bias or any motive. There's no charges against him. There's nothing. And you don't know, like you said, you haven't heard from him. You don't even know what his response would be. But he was called and asked whether he said a statement. And that even gets into another issue. He says, yes, I said it. Well, then what? It's, of course, it's up to the defense at that point. But if he says, yes, I said it, why in the world if they want to call anybody, they got what they wanted? I mean, you better call, you can't call it Boutros, because she's going to be a consistent testimony then. And for them to call Ms. Bradley at that point to question what they wanted, the officer gave them what they wanted, he made that statement about asking the other officer to lie. That doesn't make any sense. If he comes in and he maintains, hey, I didn't say it, I never said it. Well, at that point, they're going to bring Ms. Boutros in and say the opposite. But to bring Ms. Bradley in, would just say it would be a consistent statement. But she is going to say, be consistent with his testimony. So we have those issues, but then I agree that, there is an exception that the court cites in its order yesterday, but I don't see how they're going to be able to discredit the witness through bias or lack of competency when there's nothing pending against the officer. There's no reason for him to come in and lie. I would say to the court, there's a lot of arguments were made in the state's memorandum of law was filed Monday in support of an order denying the defendant's motion to use the state attorney's office. Those arguments apply here because they're looking at the same thing. And that's why I apologize to you. I don't mean to be going against your order, but I'm just having to renew those arguments because they apply to both cases in the sense that you're looking at whether or not the Brady Act. And so I would ask to adopt the legal reasoning that's found in the state's memorandum of law in support of an order denying defendant's motion to use into these motions, the arguments with the state on the motion to dismiss. And then we offer to the court to take a look at give an in-camera inspection of the proper in-camera inspection of the investigation itself, to see whether or not the court can make a further determination as to whether that's collateral to the issue, because that's the first step in Brady. It's got to be material to this case.
See, they trying to drop it.
When you have
Dismiss
another case, it doesn't fly. The defense has gone a step further, giving a proffer, trying to say it was corruption in the state attorney's office, hiding things. And again, none of that was shown to the court. That's not part of the record. So the court made a reasonable ruling on the motion to be quashed. They're not testifying. Therefore, they have to with the testimony of Ms. Rder and the testimony of Ms. Bradley And that certainly doesn't rise to the level of a due process violation. There's been no showing whatsoever of institutional issue with the state attorney's office itself. The court made such a comment, for the most part, never said that there was even prosecutorial misconduct. So to get to a due process violation that would require dismissal of the indictment, they don't have the evidence of that. And therefore the court must dismiss or deny the motion to dismiss the indictment.
Thanks.
Your Honor, to the extent that you were going to revisit the Brady issue, I was not prepared to argue that today. I didn't think that's what was on for today. And if you are going to be reconsidering that issue, I certainly like the opportunity to address it with the case law that I have and the files that I have and whatnot. We think your order as to that issue is exactly on target, and we do not have a problem with it. I do want to point out just one thing that was said, and that is that Detective Moretti getting on the witness stand, and if he acknowledges that he said those things, we can't impeach. So the state is saying that Detective Moretti would get on the witness stand and confess to a third-degree felony and probably some misdemeanors. And that's part of their argument. You know what? If it turns out that way, that he's willing to confess to a crime on the witness stand, we'll live with it. Other than that, I stand by my other arguments.
Thank you. So, Council Officer ruling take under advisement, state asked and offered an in-camera inspection of Ms. Boutros' state attorney investigation. Any objection to that?
Your Honor, yes, because we know that a lot of the stuff was verbal comments that were made. And I don't know how the court gets those verbal comments that were made to each other and whatnot. So I think you're only getting half the picture.
We're going to talk about that. As far as the transcripts of both Ms. Bradley, the testimony, not trial testimony they give. Give me a minute. Sorry, no, take your time. Give me a minute.
Judge, what if I can address the transcript?
Just 1 second, all right? All ready?
Your Honor, I think it's important to just note the sequence of events as far as Detective Moretti. Detective Moretti's statement occurred after the seizing of the phone from Ms. King, after the search warrant and whatnot. It's all part and parcel to this case, as the court has found. Bottom line of it, Your Honor, is we just stand by our motion.
Thank you. Ms. Liberty wanted to chime in. I was asking you about the transcript because you're saying that you're relying on the evidence from the trial hearing testimony from both Ms. Boutros and Ms. Bradley. And I was just inquiring as to when you anticipate having that. Ms. Liberty was chiming in. She offered me a suggestion that day.
So we tried to order the trial transcript. We were quoted $5,000 for the cost of that hearing transcript. I said $5,000 is a little expensive because we're still having them work overtime, getting us the transcripts for the last trial at this point. So we don't have the transcripts. I think even if I was to order it on a regular order, not rush, I'm looking at a month.
Thank you. I don't know about that. I don't know how long it takes to be candid with you. I don't keep track of that, but it's, I don't know that you need this overnight or anything. I mean,
No.
we have 30 plus motions to resolve.
And I think you just need it for the record right now.
Right, I took my own notes and things like that.
Yeah, so we'll just order it normal, and then we'll supplement the file.
Is that all right?
That's fine. So,
So let me switch topics. Who's going to handle this?
We just received your order yesterday, so they're working on it nonstop. So we'll have somebody.
And again, I don't know what the state's anticipating. I mean, no, I don't take it as any disrespect or anything like that. Or you anticipate filing something with the higher court to challenge the ruling or not? Or is that something still in discussion or debate? I'm trying to get an idea of where we're going and what the schedule's going to be like.
There is still some discussion, but as of right now, no, we have not.
So you're still in the process of trying to find out who the attorney is going to handle the case.
That's correct. And we're close to a decision, but we don't have any stuff that we need for the moment on that issue.
Always welcome, counsel. The issue I have going forward is we started talking about hearings starting on Monday with some of these motions. There's in excess of 30, fair enough? In excess of 30 motions that are outstanding. I know there's 13 motions to suppress, and I need to get them scheduled because we're on a time crunch. So when and where, and I believe I wasn't present when it happened, but my understanding was Ms. Liberty was trying to find out and get some time for hearings. At least my office was contacted the other day, and they were asking about when we scheduling hearings. I told them we'll talk about it today. I told my secretary to tell Ms. Liberty we'll talk about it today. I'm trying to get an idea of when we can schedule these hearings so everybody knows so we can get on it. Because there's a lot. And I know when Ms. Bradley was here, she was talking about on some of them there was issues that were, I don't want to say commingled, but their same testimony might be to resolve those issues, and we could take 3 or 4 of them on the same day, something to that effect. I don't know if those discussions, who's having those discussions, and what scheduling has been agreed to at this point.
I'll answer that for you, Your Honor. Ms. Bradley and I have a failure to communicate. As one of my favorite movies always use that phrase. Bottom line of it is that we did not work out any scheduling orders. In fact, we have a disagreement as to what motions can be heard.
And Judge, also,
Excuse me, I'm sorry.
I'm sorry.
I don't understand as to when you say what motions can be heard.
Well, I believe Ms. Bradley would contend that some of the motions are moot because they've been heard before or whatever, and I think she would contend that some of them are not going to be heard because they're not going to be introducing that evidence and whatnot. So I don't know which ones the state thinks are right and which ones aren't. Right now, all the ones we filed, we believe are right until we find out otherwise.
And Judge, I spoke to Ms. Bloom before this hearing started.
Ms. who?
Bloom.
Blue.
Yeah, sorry.
I thought you said blue.
I mumble sometimes, I apologize. So anyway, the state's position is we got to figure out who's going to be handling the case. And as soon as that happens, we'll get with the new prosecutor and try to work out all the logistics. And of course, the side issue is the state listed, 20 new witnesses. 22, I was close, that we have never heard of before that we need to take depots. So we're going to have to try to schedule in between jury selection and everything else in motion practice, that part. So we'll discuss.
Excuse me 1 second. Do you know who these witnesses are?
No, I know there was new witnesses listed, but I cannot tell you the relation to the case.
This has to do with the new allegations.
I believe this has to do, it may, but I also believe it has to do with the main case.
May I respond, Judge?
I'm just trying to get an idea.
Sure.
I was preparing a motion regarding these depositions because I've been trying to schedule depositions for about 3 weeks. As of yesterday, I finally just laid out number 1, number 2, number 3 to Ms. Bradley who needs to be deposed. They are not all regarding the new case. Actually, we've seen motions saying nothing about the witness tampering was going to be brought up in the murder case for Mrs. Klinger. 2 motions. So we got, I believe, 10 inmates that are testifying about gang activity, which would be after the date of the murder. I don't really think it's relevant, but we have new experts on the case. I did in an email ask where are the reports for the experts. I was told she was at the doctor's office and she would get back to me. Instead, I got your order recusing her. I did try to speak to counsel today. I offered up my Saturdays and Sundays to get these witnesses done. I have 3 of my own motions going specifically to evidence provided in the saw mapping and the pedometer. I have been given a new witness for the pedometer. I'm assuming after I wrote the motion to keep Detective Moretti from testifying, the state added somebody else now to testify about the pedometer. I need to depose them immediately.
Thank you. So, when is this decision going to be made as to who the attorney is?
It'll be made very, very soon. I'm sure it'll be made by either the end of today or by Monday.
Well, Monday, we're supposed to start hearings. So assuming we started the hearings on Monday, who's going to be? Is that you?
You're right. Well, yeah, it may well be, but I can't really answer as to who it would be other. And I also want to, when counsel said that in my motion, anything in my motion referred to the investigation and asked you to look at it.
You know, your motions were really clear that none of the evidence from the witness tampering case would be used in the murder case. You wrote it twice in two different motions.
Your Honor, if I may, let's conclude on behalf of the state. The state's motion and memorandums are very clear. This is regarding the witness tampering investigation and is through justice conducted. This has nothing to do with subsequent arrests that were made. And as Mr. Klinger indicated, this in-camera hearing or in-camera review is for specifically that investigation, which still remains open. And it has nothing to do with the conversations that the counsel had indicated it's all verbal. It has nothing to do with the conversations that occurred after the fact, after the statement by Mr. Moretti. This is the actual or the subpoena, the purpose for the statement. It's an open investigation, and it's nothing to do with the pending charges and the new arrest.
So this is the way, I told you I would defer ruling on that issue as well as the motion to dismiss. I'll let you know. We'll conduct an in-camera inspection of what's going on in this inspection, or excuse me, in the investigation by Ms. Boutros. My concern, I guess, is we're supposed to be in trial now, and I know my order upset the apple cart a little bit because we don't know who this assistant state attorney handling is. The case, but the concern, I guess, is that this is a speed trial where it's an issue. My understanding is that once the speedy time expires, I think it has already, hasn't. No?
We got reached the verdict on the 21st. 21st falls on a Saturday, so under timing rules, it would be the next Monday, which would be the 23rd.
So you have a better, you've looked at this, so you think it expires when?
The 23rd of this month, October 23rd.
All right, so October 23rd of this month. So, and I know there's, certain other caveats that have to happen. Council have, they have 30 motions that they filed recently to the new defense team, new additions to the defense team. And there's a lot of motions that need to get heard. I understand all of that, but we all are under the gun, so to speak, because there's speedy trial. My understanding from the defense, they've made perfectly clear they're not asking for continuance. They want to have the motions heard and they want to be able to go to trial. That's the way I understand it. So it's really imperative that I know who's handling the case for the state.
I understand, Your Honor. And again, I think, you brought up the defense continuously. We wanted to both witnesses. They are filing motions. They should be taking a defense continuance and holding hearings in their case. However, I also have another solution for the court if the court doesn't find me giving one, and that would be Judge Fine picked a jury this week on a capital case. He had 250 jurors coming in next Wednesday. They reserved for it, but they got the jury this week. Those jurors are in fact available, so that the court could go ahead because of the prejudice in the state in the sense that we now have a new prosecutor on the case. And this prosecutor has to get ready. And in order not to prejudice the victims' families and the state and the people of the state of Florida, you could bring a panel in on Wednesday, swear them, and have them come back later on or after the holiday. And then we have to get speedy trials. All of these motions could be set and depositions could all be set within a reasonable time period. And then the jurors are coming back without any other issues with speed. And they could be heard with everybody having a chance to be prepared.
Understood, and I don't disagree with anything you said. but that doesn't mean that's the way it's gonna happen. It's a distinct possibility, but it's also, assuming that if this defense intends on filing a notice of expiration on, you said 23rd is the date, is that right?
Yes, unless tomorrow goes the 21st.
Speaking from the 23rd, they would have to file a notice on the 24th.
So if they intend to file their notice on the 24th, I intend to start the trial. And, no disrespect to defense counsel, these motions and depositions are going to be put to the side, so to speak. We're going to go forward on trial. That's what you want. That's what we'll do. If you want to get the motions and the depositions taken care of beforehand, I mean, we're going to go on trial Monday through Thursday. I think that's what Ms. Bradley and you all indicated that you want to do on it. You want to say Fridays for whatever type of work you were doing. And I said okay to that unless there's some change. I'll find out who the new prosecutor is on it. We can talk about it, but my thought is we're going to be going Monday through Thursday, and you can do what you need to do on Fridays.
I think our calculation maybe speed runs earlier than the dates of their.
I think it may be on that Friday.
It might be on the 20th, so.
Yeah,
I'll take it. I'll take the 20th. I'll take the 20th, Judge.
I think you're right.
So there may be less time
Great.
in that sense.
Whatever it is, and you'll know and you'll let me know. But the point is, we're up in a time crunch.
And let me ask also for, I appreciate for at least considering the proposal that I made. And also, I know the court's ruling, and it seems as though that a ruling on Ms. Bradley applies to trial, because that's how the defense process was to be violated during trial. Is the court ruling that she could not handle the motion, still not handle the motions themselves?
She should be out of the case now.
Judge, the only other thing I wanted to add, Your Honors, the state Crawford and Your Honor agreed to see these materials in camera. If
I didn't agree with that.
Oh, they could under advisement. So if in fact we do decide to do that, let us know. And we just ask if you find that it's something that we can have and it is discoverable, we'd like a copy as soon as that decision would be made. That's all.
Well, they're telling me it's something about an ongoing investigation. It's still pending. So typically, that is not something that will be shared with the defendant. I don't know what it pertains to specifically. I have no knowledge of it, but I mean, if it's something that I don't know.
Sure, and that's why I'm asking is that this began before October of 2022. So if it's still ongoing, if Your Honor notices that there's no activity since October of 22, that maybe there would be more to it than just them categorizing it an ongoing investigation. So that's all I'm suggesting is that it may be discoverable regardless of how they label it.
You need to get rid of him.
Still would help the court if the court wanted.
Don't get on my nerves.
I don't know if something I want to look at, because if it's an ongoing pending investigation, it's not something I can really share with the defense. And I don't like that. I never really liked doing that, to be candid. So it's not something you can share on the court. I don't know what my feeling is, so let me think about it. All right. But I need to know about the attorney, because I need to know when I can schedule hearings. And there's 13 motions to suppress, and I want to get those resolved. I don't know if the witnesses, I assume they're under subpoena for the trial period now, because we're supposed to be starting this week.
Your Honor, the last time you made that comment, Ms. Bradley was here, and she said because jury selection was going to take so long, that the witnesses were not under subpoena.
So if that's the case, I don't know if it's the case or not. I mean, I don't remember what Ms. Bradley said, but if that's the case and there's no witnesses under subpoena, how long would it take the state to get witnesses for these motions?
As soon as we know, it won't be long, who is going to be handling the case, will advise the defense of the court. And that is why, again, suggestion of taking the jury to find that certainly help in the situation, certainly prejudice in the state in the sense that for a new prosecutor to take over this, it's a double homicide, we're asking for the death penalty, it's a case. That's a lot for a prosecutor to, on last minute, to be trying to learn and to understand and be able to make an argument on. And that's why we made the suggestion to the court of holding in the panel next week on Wednesday, swearing them in, asking them to come back, and then letting the prosecution have the time to prepare for such a large case and these complicated motions. And we'll also give the defense time to do their depositions and file whatever new motions they can file.
Thank you. Anything else to discuss at this point?
I do have, so since we're doing scheduling, I did have one motion that's not a motion eliminating. It was basically, started off as a motion to compel, which would be my second one, to get the self-map evidence. We did get a new expert, which I listed. My new expert went through the documents and then informed me that all the CDRs that the state has been provided are not what comes from a cellular company. They went even further and pointed out that somebody went into the evidence that's supposed to be direct from the mobile company and put phone numbers, the names, assigned names to phone numbers. So I would ask that that hearing be held as soon as possible because we do have an huge evidence issue that needs to be resolved immediately.
Thank you. Well, I'm not going to get involved in that until I know who the prosecutor is. I need to know who the prosecutor is. So my thought is I'll set a hearing. If you have decisions going to be made, you think today or Monday?
Y'all ain't did
So
nothing
if I put
today.
this on the docket for Tuesday, that work? You'll know who they are, and somebody's going to have an opportunity to discuss. I guess whoever's going to do it is going to discuss with the defense counsel about scheduling these motions and which ones are going to go first and which ones you want to do and which ones you need testimony on and where the witnesses are, whether they're available, and how long they're going to be. There needs to be some discussion regarding that with the defense counsel.
I have the bulk of the motions I've written that I will be happy to coordinate in any way I can with the new state.
All right, so are we done? Yes?
And Judge Walker, on the record, I do have 4 USBs that were provided by Ms. Bradley to provide feedback, so I just want to do that on the record.
Thank you.
Thank you, Your Honor.
Can I see counsel sidebar, please?
They ain't did. They kind of like think they waste all this time. See, they don't got rid of Bradley. See, they did this on purpose. If that man don't know what he doing, he don't need to be up there. He just don't want him to call that girl up there. That's what they don't want him to do, call his girlfriend up there. They don't got, ooh, wait. It's a mess. Melly don't even supposed to be doing that. See, they doing all this illegal stuff in Florida. Yeah. They waste all this time for nothing. Just showing up. Now they get ready to go. Well, y'all. Okay. I guess y'all will meet up the next time. Appreciate my super chat. Appreciate the ones who viewed today. Appreciate the ones in chat today. Appreciate my my mods. And that's it, y'all. I'll see y'all later, okay? And thank you so much.